ladies and gentlemen. I'm Howard Marcy. I'm the hearing officer today for this matter. For the record, today is August 23, 2018. We are in the City Council chambers of Oviedo, Florida. The purpose today is to consider the application of the Florida Department of Transportation for an eminent domain deviation for real property located at 10 Windsormere Way in Oviedo. It would be lots 10 and 11, Windsormere Plat Book 59, pages 1 and 2. Going to start with a little housekeeping to maybe make things move on a little more quickly. First, I'm going to receive into evidence the deviation application filed in this case by the Department of Transportation. I want to give a copy to our court reporter. And a copy. Gentlemen, I assume that you have copies already. If not, I have extra copies for you.
There have been several applications filed.
Okay. Well, here is.
So I'd like to know which one. What is
Sure.
the date on
Okay. If there are others, you feel free to offer them in evidence later.
And also, just for the record, we're only here on lot 10.
Okay.
Lot 11 is we're not here representing.
Okay. Thank you. All right. Next, I'm going to enter into the record the State of Florida Department of Transportation eminent domain resolution. And next, going to enter into the record Section 2.9 of the City of Oviedo's Land Development Code, which is the pertinent section governing eminent domain deviations. The deviations sought are a 14.2-foot deviation to the front building setback from the north property line, which fronts State Road 426, to a setback of 10.8 feet. That is a deviation of 57%. Also sought is a 10-foot deviation to allow a minimum north landscape buffer yard of 200 feet. I'm not sure that's 200 feet. That should be 2 feet, is it? I can't read my writing. Along State Road 426, that's a 100% deviation. And lastly, a 4.2-foot deviation to allow a minimum west landscape buffer yard of 5 feet 8 inches along the west property line along Windsormere Way. That's a deviation of 42%. I'm the hearing officer today. I have been appointed by the City of Oviedo City Council by resolution number 3577-18 to hear and decide this application. Going to enter into the record at this point in time that resolution, which establishes my authority to render an opinion today. Deviations have been recommended by the staff of the City of Oviedo Planning Division. I'm going to enter into the record at this point in time the compiled comments of the staff.
Excuse me, Mr. Marcy, we have not been provided with those staff comments.
I anticipated that.
I apologize. I stand corrected.
Oh, okay.
I'll take a copy.
But there are copies, nevertheless.
And also, Mr. Marcy, the application that you're going to do is not a complete application.
Okay. Well, we'll let you address that we'll let you address that. All right. The housekeeping is out of the way. Want to let representatives of the DOT and the owner identify themselves. Gentlemen, the City of Oveda's hearing officer requirements do require that counsel for the parties place on the record that they are authorized to act and bind the respondent to any orders entered by the hearing officer. So, gentlemen,
Good morning, sir. My name is Tim.
step up to the microphone if you would here. Yes, everyone, if you would, speak into the microphone. We are being recorded.
Very good, sir. My name is Tim Dix. I'm here on behalf of the State of Florida Department of Transportation, and I have the authority to bind the department to any decision which you would make this morning.
All right.
Good morning, Mr. Marcy. My name is J. Christie Wilson III. I am here on behalf of Walker Properties, the owner of 10 Windermere Place. I do have their complete authority to make representations on their behalf. We do reserve the right to seek review of any decision that's reached today.
Sure. All right, anyone else who's going to be speaking today addressing this? If so, step forward to the microphone and identify yourself.
Good morning. I'm Phil Hirsch. I represent AECOM Engineering. We are the engineers who prepare the sketches, the exhibits, and the report on behalf of the department to support the appraisal.
And the last name again was?
Hirsch, H-U-R-S-H.
H-U-R-S-H.
Correct.
Okay. Who else is going to be speaking today?
Good morning. I'm Kate Spiess with Inwood Consulting Engineers. I was the
Kate?
Kate Spiess, S-P-I-E-S-S. I'm the engineer of record for the design plans for the widening of State Road 426 and County Road 419.
All right. All right.
Good morning. My name is Paul Sherma. I'm with Professional Engineering Resources. I'm the engineer representing the owner.
Okay, and how do you spell your last name?
S-H-E-R-M-A.
All right. Anyone else that's going to be speaking today? Anyone going to be speaking on behalf of the city?
I am
All right. What is your name, ma'am?
Anach Whitfield, Planning Manager of the Planning and Zoning Division.
All right. Ms. Whitfield, we'll begin with the city. Do you have anything to present?
Yes, sir. As you had mentioned, this is a request for you acting as the hearing officer to render a final decision regarding the deviation application under Land Development Code Section 2.9, which deals with eminent domain for the subject property located at 10 Windermere Way. I wanted to just point out very quickly that this legal description is lots 10 and 11 per the Seminole County Property Appraisers website for the property addressed at 10 Windermere Way. The DOT adopted a resolution that commenced an eminent domain process upon and is in the process of acquiring a portion of the property located at 10 Windermere Way relating to State Road 426 roadway improvement projects. As part of this eminent domain process, DOT has submitted a deviation application to request deviations to building setbacks and landscape buffering requirements of the Land Development Code for the subject property as part of its CURE plan. City staff has reviewed the requested application pursuant to our codes and identified no concerns relative to the requested deviations. City staff recommends approval of the deviation application. The property owner of 10 Windermere Way objects to and does not grant DOT's permission to submit the application to the city to request such deviations. Section 2.9 of the city's code allows the city's land use administrator to act upon such deviations to allow the continued use of the property in a manner similar to its preeminent domain conditions. Since the property owner objects to the deviation application, it appears that any consideration by the land use administrator will be contested. City staff believes that any decision will be appealed to City Council for another hearing, so to avoid having the applicant and the property owner go through two hearings, Council voted to adopt the resolution to hold the one hearing in order to provide an economy of efforts. The city staff's review based on our code deals with impacts of the deviation to surrounding properties, whether or not pedestrian safety would be impacted, whether or not off-street parking would be impacted, pedestrian sidewalks would be impacted or encroached upon. DOT's cure does not affect any of those things that the city staff considers. The building stands where it is, the parking remains where it is, the drainage system in the area isn't affected by the cure, so staff is recommending approval of the deviation application and request that the hearing officer conduct this hearing on said eminent domain application and render a final decision.
All right, thank you. All right, Mr. Dix, you're the applicant.
Good morning, sir. I have to apologize first thing this morning. I have never been through a hearing like this or advocated for the department in a hearing like this. So if I step out of bounds procedurally, please let me know, sir, and I apologize in advance.
Yes, incidentally, gentlemen, we do have 1 hour set for this. I've read all the documents, so I have a pretty good idea of what we're here about, so don't feel the need to overly educate me, but I understand you need to make your record. Everyone's probably already noted that the city staff recommended this, and typically, because the Land Development Code 2.9 provides that either the property owner or the DOT may apply for the deviation, it would sort of routinely be granted. I do understand their objections by the property owner. I leave it to you gentlemen, but maybe a better way, more efficient way of handling this today is to let's hear the property owner's objections.
Yes, sir. That's what I would recommend.
Okay. Well, Mr. Wilson, we'll hear from you then.
Thank you, Mr. Marcy. I would like to ask a few questions of city staff, if I might,
Sure.
so that we can, because...
Address them to me, and then we'll see if we can get answers. What questions do you have?
The first question I have is, in the Muni Code, there are certain considerations that go beyond what were mentioned in the city's presentation. One of the considerations is that they have to minimize they have to be satisfied that the applicant is minimizing the extent of the deviation they're requesting. And I will tell you that is a matter of concern for us. If you look at the application that the city that was filed by the DOT without our consent and without any attempt to contact us beforehand and say this is what we're doing, and it was presented to the city with no notice to us. We just happened by happenstance to find out about it, and there is no provision in the code that requires any kind of notification, and I think that violates the Fifth Amendment of the Constitution, because we're entitled to due process when someone else is trying to get a permit or a variance on our property, and there's absolutely no provision in the city code to provide that notice to the property owner. And Chapter 166 of the Florida statutes requires notice when there's a significant zoning matter, not only to the property owner, and you would think certainly to the property owner, but also to adjacent property owners when there's likely to be an impact on them. And Mr. Marcy, I will tell you, we're in favor of protecting our property from an eminent domain case. What is being proposed here is not a covenant that runs with the land. What is being proposed here is to create a legal nonconforming use, which if there's any kind of fire or major impact that destroys the statutory percentage of the value, the tax assessed value of the building, that's gone. And we're going to have to put the building back in full compliance with the code because of this taking. It's my understanding that's what's being sought, and I wanted to clarify that. But getting back to the minimization requirement of the city's own code, we have an issue here. I dealt with another property just down the street from this one where we had a taking. And Inwood was the design consultant for that one as well. And it was a breakfast restaurant. And Mr. Sharma worked with me, and he's prepared to testify if necessary about that. But when we got down to brass tacks, we discovered that they didn't need all the property they were trying to take. And why is that significant here? Well, it is because their own construction plans, which they've attached, and I will point out to you that in their application, the setback numbers are different from the setback numbers that are contained in the resolution. I don't know why they've done that. They're a mistake or something. But if you look at the application and you look at the tabulation form in the application and you compare that to the resolution, the numbers are different. But the point of the matter is, without getting too hyper-technical, the point is that there are about 5.8 feet. The DOT is putting a retaining wall in because the road is above the property. It's actually, they're not changing the elevation of the road that much, but they're moving it much closer to the property. And so that elevation becomes much more exaggerated, that difference. And they're putting a retaining wall that goes from about 2 feet to 3 feet along the property line. And that retaining wall is the edge of the construction as we understand it. The plans show nothing else being placed on the property side of that retaining wall. And between that retaining wall and our new property line is 5.8 feet. And if you're going to minimize the need for the relief from setbacks, that 5.8 feet should be considered. And frankly, the DOT, as you know, you've dealt with eminent domain cases before, the DOT is not allowed under the Constitution of the state of Florida to take any more land than is reasonably necessary for their project. So if they don't, and we see no, on the construction plans, we see no indication whatsoever of any kind of use of that property. If they need it for temporary construction, they can take an easement. Seed Aid Industries says you don't take a greater quantity or quality of title than is reasonably necessary. So we feel that's an issue. Also, we're concerned because in the last year and a half, there have been two pretty significant changes to what they're taking from this property. The DOT initially was going to take at the, I guess it's the east end of the property, the DOT was going to take a rather large temporary construction easement that actually went into the building for the purpose of moving a manhole that has to be relocated as a consequence of the right-of-way acquisition. Then the next thing we knew, there was no TCE for that. And then they changed again, and now there is a TCE, but it's smaller. So we've had three changes. And I've been advised by the DOT that they're not even going to file suit until June of 2019, and the right-of-way won't be required to be cleared until 2020. And my concern is that this is very premature because we're not even sure yet exactly what the taking is going to be.
Has there not been an order of take yet?
No, there's no order of taking. Suit hasn't been filed. There's been an initial offer to the owner, an initial appraisal, which will have to be updated because it'll be stale by the time the taking comes around. So suit hasn't been filed, and it seems to me if we're successful at an OT in defending against the extent of the taking, which we in good faith intend to contest, then we would have been given a setback requirement that would allow us actually to expand our building beyond where it is today. And that's not the intent of this. But so those are the concerns I have. I have a Fifth Amendment concern about notice, and we got notice inadvertently. We're here today, but just the nature of this statute, I'm challenging it on its face because I think it's unconstitutional. So that's number one. And number two is I don't think that the application, and there are 2 pages to the application, the 2 cover pages where the information is actually filled in. That's significant because an affidavit is required if the person not filing the application, if the person filing the application is not the property owner. There is no affidavit that's attached, that's notarized. That's important for future reference. The points, again, I'm sorry I'm going around here, but the points that we have are, number one, Fifth Amendment issue with due process and the lack of requirement for notice. Number two, that we don't think the plans that have been submitted demonstrate a need for the variance that's being sought. And thirdly, the variance is premature because we don't know. We haven't had an OT. We don't know what will be allowed or not allowed by the court. And the variance, which if I didn't state before, I state again, is something we want. We don't want to have to tear our building down if we don't have to. But we want to have the proper variance, the proper facts. And the taking may be even more severe, which would require an even greater variance. We don't know at this point. And these takings, my 35 years of experience in eminent domain has taught me that these things shift quite a bit over time. And sometimes they don't, but sometimes they do. And rather than go through multiple variance proceedings, it seems there's no urgency for this because the taking, they're not going to be constructing tomorrow. The taking won't occur. We'd ask that this be postponed until we know exactly what is being taken. And there's plenty of time between the OT and when they have the right of way to do that.
Well, and I assume that once the order of taking has been entered, the property owner would be seeking a deviation.
Yes. That's consistent with what the court allows the DOT to take from us.
All right. Anything else?
No, that's it. I'll introduce the plans into evidence. And may I just call Mr. Sherma just
Sure.
briefly? Do you need him to?
If he's going to testify, I'm going to put him under oath. But
Okay. Fair.
Yeah, step to the microphone, Mr. Sir. You raise your right hand. You solemnly affirm the testimony you're about to give shall be the whole truth and nothing but the truth.
Yes, sir.
State your name for the record.
Paul Vito Sherma.
All right. Mr. Wilson.
Thank you. Mr. Sherma, you're a licensed engineer in the state of Florida.
Yes, sir.
Mr. Sherman, did you have occasion to work on other properties with this widening that are west and north of the subject?
Yes, sir. Yes, sir.
And Mr. Marcy, I will ask for, correct myself. The DOT has 2 parcel numbers. They have 10 and 11. And parcel 11, or parcel 10, I'm sorry, is not our parcel. Parcel 11, which is lots 10 and 11.
Yes.
So there's the confusion.
Okay, lot 10 and 11.
Yeah. Mr. Sherma, did you have occasion to work on a restaurant that was located east of the subject?
Yes, sir.
And did the right-of-way change with respect to that restaurant?
Yes, sir.
Was there a determination the DOT had taken more than, or was seeking to take more than they needed?
Yes, sir.
And did the DOT correct it and take less?
Yes, sir.
Have there been changes to the design of the project as it affects this property?
With regards to the easement, temporary easement, yes.
And you've looked at the construction plans, have you, sir?
Yes, sir.
Do you have a copy of those with you today?
Yes, sir.
I'd like to introduce those into evidence. As Exhibit A, composite Exhibit A.
Okay.
Mr.
Okay, it will
Chairman,
be received in evidence,
I apologize.
right?
I would just point out, it says Exhibit 1 on the document itself, but for purposes of this hearing, we're calling it Composite Exhibit A. Mr. Sherman, referring to Exhibit A, did you make a determination of where the edge of construction is going to be as indicated in the plans?
Yes, sir.
And is that at the right-of-way line?
No, sir.
How far in from the right-of-way, in other words, towards 426, is that construction stopping?
There is a proposed retaining wall parallel to the proposed right-of-way line, and it varies across the front of the property from 5.7 feet to 5.8 feet, and that is shown on the first page at Station 120. From the retaining wall to the proposed right-of-way line is 5.8 at Station 120 plus 50, 5.8 at Station 121, 5.7. If you go to the next page, which are the cross-sections, I've shown the gravity wall is shown as brown with the fence railing on it, and you can see there in the cross-section, Station 120, the engineering plans show the proposed right-of-way line. I've highlighted in blue, and the distance from the retaining wall to the proposed right-of-way line is 5.8 at Station 120. At Station 120 plus 50, again, 5.8. And then at Station, the next page, at 121, the retaining wall from the proposed right-of-way line is 5.7.
So the main point you're making, Mr.
Is
Sherman,
that they are acquiring more right-of-way than they need. Typically, gravity walls are set at the right-of-way line or half a foot from the right-of-way line, and they would, if they felt they needed, depending on the depth of the gravity wall, a TCE to install that gravity wall. So in this case,
Mr. Sherman, what's a TCE?
or temporary construction easement. So in terms of the city code, if you look at the city code, I believe we were referring to, let me pull it out here, 2.9
the LDC,
B, specifically 3E, states the deviation is the minimum necessary. So if the DOT were to move their right-of-way line towards the retaining wall, that deviation would be less. And also, we've talked about the building setback, but it's also the landscape buffer. Moving that retaining wall or the right-of-way line towards the retaining wall, we would be allowed to have a, if you look at the proposed resolution, the variance is to go to from a 10-foot landscape buffer to 0. Moving that right-of-way line will allow us to have a landscape buffer. So what I'm saying is they haven't minimized the impact.
how many feet are we talking about, the differential between their actual take and what they need to take?
About 5.8.
About 5.8 feet.
Okay? All right?
Mr. Sherman, just before I let you return to your seat, have you had occasion to review the application?
Yes.
Is the application that you were handed this morning, is that the complete application as you understand it?
No, sir.
Are there additional pages?
Right. The information provided this morning differs than what was provided earlier in that there are 2 pages that are missing, which provide the applicant name, the consultant, and then another page of what...
Is that the same as what we got?
No, that's this. We don't have these 2 pages. And so I can show you what these 2
Why
pages...
don't you rip those out and let's...
So the one I entered earlier is incomplete or has more information than the one you have?
No, it's incomplete.
Incomplete.
There are 2 additional pages, and we'd like
All
to
right.
enter
Would you
those
like to
together.
introduce those? Okay, these are the additional pages? All right, I'm going to accept these as the property owner's exhibit. B.
Now, finally, Mr. Sherman, did you, on those first two pages, did you find a requirement that the applicant submit an affidavit along with the application?
Yes.
A notarized affidavit?
Yes, if you were to look at that front page on the left, it says checklist.
Yes, I see that.
Right below that checklist says that if the applicant is not the owner, a affidavit from the property owner is required. I did not see a affidavit from the property owner.
Finally, Mr. Sherman, did you have occasion to compare the setbacks before the taking and after the taking as set forth in the tabulation in the application with the setbacks that are ultimately being requested in the resolution?
Yes, sir. So in the application provided today in the back, and I believe I'm reading this correctly, which would be the table form in the back.
Is there a page number?
No, I'm sorry. It's the last page. And we're looking at the bottom half. It says building setback. The requirement is 25. The parent minimum, I'm reading across from left to right, 25 feet. The average 25.7. The remainder is 2, and the average is 9.5. So that's regards to what they're saying. But when you go to the resolution, there's a proposed resolution. Do you have that? It is entitled City of Vito Development Order Relating to Eminent Domain, Action 10 Windsor Mayor Way. Under required approval, which is 4A, it says that a 14.2 deviation in the LDC section 4.12 requirement for a front setback of 25 feet to allowing an existing building to be set back 10.8 feet from the property line. The table is inconsistent with the resolution.
Okay. All right. Anything further?
No, that's it. Thank you, Mr. Sherman. Appreciate it.
All right. We'll hear from the Florida Department of Transportation. Mr. Dix.
Good morning, sir.
Good morning.
I'd like to start with addressing the due process issue. Sir, I'm going to have to defer to the city attorney on that. I think that's Lonnie Groot. I don't have anything regarding that. As I stated, I'm going to have to defer to Mr. Groot on that.
Well, just one question. Did the DOT give a notice to the property owner that they would be applying for the application?
I'm going to let my engineer speak to that, sir, the applicant, who's the project manager.
Mr. Groot's here.
Okay. Mr. Groot, do you have any opinion regarding this due process issue that's been... Sure.
No, we'll hear from him in due course if I find it necessary, Mr. Dix.
Okay. I'm going to have to deviate or defer to Mr. Groot on that, sir. As far as the application, I'm assuming the application was correct.
Yes, I'm not sure which application Mr. Wilson entered into evidence. The application, we received originally 2 applications whereby there was not a spot for the eminent domain authority to have signatory authority. The city abandoned that initial application per the guidance from our city attorney's office. We added a certification into the certification section at the bottom of page 2 that states, consistent with our code, that the eminent domain authority could act as the applicant. The section that Mr. Wilson referred to, that if the property owner is not the applicant, then an affidavit is required. In this instance, the code allows the eminent domain authority to act as the applicant or the property owner. Either the eminent domain authority could submit or the property owner could submit.
All right, but there was no, I do see in the submittal checklist, if the applicant is not the owner, a notarized letter of authorization shall be submitted with the application. That was not done in this case.
We have that for just about all of our checklist items because for every other application that the city processes, we do require an affidavit if the property owner is not the applicant. However, in this instance, the code allows the eminent domain authority to act as the applicant, one or the other. In this instance, it was the eminent domain authority. Also, at the guidance of the city attorney's office, the city accepted resolution, the DOT's eminent domain parcel resolution to commence the deviation application.
Okay, but there was no affidavit.
No, sir, there was no
Regardless of what,
affidavit.
okay.
Right.
All right. Go ahead, Mr. Dix.
As I understand it, sir, the affidavit's not required then?
No,
Well, I'll make that decision, Mr. Dix, but
Okay.
give us the DOT's position.
Very good, sir. As to necessity, I believe that's an issue that should be handled in court at the order of taking hearing. Mr. Wilson spoke of that several times. And it is true that the department cannot acquire more property than is necessary to complete the project. That's something that we address at the order of taking hearing, sir. It is not uncommon to acquire property before the actual order of taking hearing. There's a process that takes place. If there has been an offer that's submitted, the department is bound by the offer. So if the valuation changes, we're going to have to reappraise the property, and that initial offer is not going to be valid if the value changes. So it's not uncommon for the department to proceed this way. In fact, it's very common. As to the construction plans and the issue of the retaining wall, I'm going to let my engineer address that if I could, sir. The other issues, I'm going to have my engineers address too. So if I may call my first witness.
Yes, you may.
Your Honor, the department calls Mr. Philip Hirsch.
All right. You raise your right hand, please, sir. Do you solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
State your full name, please, sir.
Philip Hirsch, H-U-R-S-H.
All right. Mr. Hirsch. Mr. Dix, go ahead.
Mr. Hirsch, you're a licensed engineer in the state of Florida.
Correct.
And how long have you been licensed, sir?
Gosh, off the top of my head, about 20 years.
Have you worked on previous road projects?
Yes.
Very good, sir. Mr. Hirsch, how are you familiar with this property?
AACom is under contract with the department to provide support services for appraisal services by the department. My personal involvement is to oversee the development of engineering cure plans, as well as reports, as well as other supporting services such as planning, construction, FF&E, and so on. So my role is the project manager to manage that staff and also oversee the engineering.
Okay, so you developed the cure plan for this particular property.
Correct.
Can you briefly explain the cure plan to the board, please?
The acquisition essentially takes the front portion of the property in an angular manner, so it's not consistent across the entire frontage. Essentially, we are impacting the setback requirements for the building as well as landscaping. Other than that, no other aspects of the property is damaged through the acquisition, including the building, parking, accessibility.
And in your opinion, sir, in your experience working on road projects, is this a common practice to seek a deviation from the normal land development codes as a result of eminent domain?
Yes, it is.
Is this an uncommon situation, sir?
No, it isn't.
No further questions, sir.
All right. Anyone else have anything to offer?
May I?
Yes, we'll hear from you again.
Yeah, Mr. Marcy, may I?
Step up. Sure.
May I ask this gentleman?
Sure.
You asked Mr. Dix if he had contacted the owners and let them know that he was filing a deviation.
Well, you may address questions to the witness. Sure.
Sir, did you contact my client or me to let us know that you were filing a deviation application?
No.
Do you know if the city contacted the property owner?
I'm not aware of what the city did.
But you made no attempt to contact the property owner?
No, it's my understanding we're not obligated to through city requirements.
Your understanding, who gave you that understanding?
In the city's land development code, we are under understanding with the new change to the application that now includes eminent domain authorities as an applicant, that we were not obligated to contact the owner.
Well, the city, isn't it true that the city's code says that either the owner or the DOT may apply? That's what it says, correct? But does it say that you don't have to notify the owner? Does it say that the DOT
No.
may apply without notifying the owner?
I don't recall seeing that, no.
All right.
Have you been to the property?
Yes.
How many times?
Oh, at least 4 or 5 times.
When were you there last?
Probably within the last 3 or 4 months.
Now, are there doors on the property that open towards the right-of-way?
Yes.
Are those doors going to be impacted?
Not to my knowledge, no.
Have you looked at that to make sure?
You mean the radius of the door opening?
Yes.
Yes, I don't believe so.
Is there a fire issue with the proximity of the right-of-way to those doors?
I can't speak on behalf of fire.
So you don't know whether there is or isn't.
Correct.
And you're not an appraiser, are you?
No.
So when you talk about the damage being totally cured, you're just talking about that from an engineering standpoint,
Civil
not a
site.
value standpoint.
Civil site, yes.
No further questions.
Can you redirect,
Yes, sir.
Mr. Dix?
Mr. Hirsch, as far as you're aware, is there a requirement to contact the property owner within the city code?
No, I'm not aware of it.
I have no further questions, sir.
All right. Anyone else have anything to present?
Sir, I have one more witness, if I may.
Okay.
Sir, the Florida Department of Transportation calls Miss Kate Spees.
You raise your right hand, please. You solemnly affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Yes, I do.
State your full name for the record.
Kate Spiess, S-P-I-E-S-S.
All right. Go ahead, Mr. Dix.
Miss Spees, how long have you been an engineer?
I've been with Inwood for 18 years, and I've had my PE license for 14 of those years.
And I'm assuming you're licensed in the state of Florida.
I am.
And you were licensed for the entire 18 years that you were working with.
Well, I received my PE after 4 years of working, so for 14 years I've been licensed as a professional engineer.
Very good, ma'am. Have you worked on previous road projects?
Yes, I have.
And was that in conjunction with work for the department?
Yes.
And Ms. Spees, what's your role in this particular project?
On this project, I am the engineer of record and also the project manager for Inwood, so I've been involved with the design process throughout.
Okay, when you say you've been involved with the design process, can you briefly elaborate for Mr. Marson what that entails?
Related to the parcel or the... On this parcel, we have had, since the plans have been completed, we've had meetings with the DOT through the right-of-way partnering meetings. And on the front of the plans, you'll notice that they say 100% plans complete, working set, not for construction, printed 6/14/18, includes minor design changes that have come from right-of-way acquisition. We submitted final plans, and then once the final plans were submitted and the right-of-way acquisition began, there have been little changes that have come about. Nothing major. The road is still the road, and it's where it's located. But I know that Mr. Wilson had talked about the right-of-way line changing and the temporary construction easement changing on his property. So throughout that process, that is what happened with the right-of-way line. We did not, the strip take across the front of the property is the right-of-way that we need for the construction of the road. The part that had changed was on the east side of the property. There's a manhole, an existing manhole, that is in conflict with the gravity wall, and then that system continues south along his property. Originally, we were going to remove the manhole and remove the pipe up into the next inlet that was there, And then from all these meetings, it was determined that the best thing to do would be to just remove the manhole and plug the pipe and leave everything in place on their property, since it was their system. And that is how the right-of-way is no longer notched out, and there's just a small temporary construction easement to facilitate the removal of that manhole and plugging the pipe.
So if I'm understanding you correctly, the bounds or the area of the temporary construction easement changed?
That's correct.
Okay, and that was based on the manhole situation?
Yes, originally it was as right-of-way, then it was changed to the temporary construction easement, and then the shape was changed.
And Ms. Feast, do you anticipate any further changes?
I do not.
Okay, and if you would, let me mention it for the record. Do you anticipate any further changes regarding this particular property?
No, I don't anticipate any changes on this property.
Okay, and if you would, ma'am, for the record, would you just go ahead and bind the department to those plans pertaining to this particular property?
How do I do that?
Well, when I ask you to do that, what I'm asking you to do is you can bind the department, or you can bind on behalf of the department that the construction plans are not going to change.
I'm going to object. I don't think this engineer has authority to bind the department.
Well, I'm going to overrule the objection. Go ahead.
To my knowledge, there should be no additional changes on this property, on the right-of-way to the property.
And ma'am, let's talk about the retaining wall pertaining to the parcel. Has the retaining wall ever changed, the location of the retaining wall?
The location of the retaining wall has not changed. There were some different iterations with what was happening behind the wall. Originally, there's a ditch behind on the property that the retaining wall will be up against. And after going through, we now have a approximately 5 foot level area behind the retaining wall for the stability of the wall, to make sure we don't have slopes right up against the retaining wall. If you look throughout the project, other areas with retaining walls, the existing ground is fairly level already at those areas. And if you refer back to DOT indices with gravity wall, they talk about having a level area behind the gravity wall. And in our cross-sections, and shown on the plans that Mr. Wilson entered, we do have an elevation called out where that flat level area behind the wall should be constructed.
Very good, ma'am. Is it your opinion, as a design engineer or as a design engineer for this particular project, that the department or the area or land that the department proposes to acquire is necessary?
Yes, the land is necessary.
I have no further questions, sir.
All right, thank you. Do you have anything further to present, Mr. Dix?
No, ma'am. No, sir. That's my last question.
Mr. Wilson, do you have anything further to present in the way everybody? Yes, go ahead.
Has Inwood ever changed the construction plans after submitting 100% plans?
Yes. The plans.
You did it here, didn't you?
Yes, we did. The plans, and we've done it on other projects as other engineers do as well. The plans were submitted, we go through right-of-way acquisition, and then we have a design update phase. And that incorporates all the changes from when the construction plans were completed to when actual construction starts.
But you haven't been through right-of-way acquisition yet on this parcel, have you?
It's ongoing, and we have already had at least one order of taking hearing on this project.
Have you had an order of taking hearing on this parcel?
Not on this parcel.
And the 5.8 feet varying, 5.7, you don't disagree with Mr. Sherma's?
I don't disagree with his distances, no.
That flat area, you could have an easement across that area to prevent the owner from building it up, and at the same time allow the owner to use it to meet his setback requirements, couldn't you?
In this instance, we decided that right-of-way would be necessary.
That wasn't my question, ma'am. My question is, you're going to flatten the area, and as long as that area stays flat, you're not putting anything else in there, are you?
At the moment, we have a sign near the corner on his property, and we also need to provide space for utilities in the area. At the moment, there's nothing planned, but as part of building a road, the DOT has to make sure they provide adequate space for utilities as well.
Does the owner have utility easements across the front of his property?
I'm unaware of the utility easements of
You
the
don't
owner.
know.
Right.
So you don't know what use, if any, is going to be made of that 5 feet other than to level it up against the retaining wall. Is that correct?
I'm using it for the stability of the wall, to construct our plans, for signage. It's necessary to construct the project.
Well, you need at least a temporary construction easement to put the wall in and to flatten it. But beyond that, you don't need to have fee title to that, do you?
I can't say one way, I can't say that. I believe that we need fee title to that land.
But you can't say whether you do or not.
No, we need this land.
Okay. Now, have you gotten your permits yet?
Which permit?
Construction permits?
We have
Water management
Yes, we
district?
have the water management permit.
And what other permits are required for this project?
An Army Corps of Engineer permit is required. Oh, I'm sorry. An Army Corps of Engineer permit is required.
Do you have that?
We were, when their offices switched, there was a delay, but we're in the process. We should be receiving it any day now.
So you
Mr.
don't-
Dix, you have an objection?
Yes, sir. Mr. Marcy, I have an objection. We're getting into the arena of things that should be covered in the eminent domain or taking.
I agree, Mr.
Yeah,
Marcy,
I'm
100%.
going to overrule the objection.
So are there any other permits that you don't have yet?
No,
So you're waiting on the Corps of Engineers permit.
which they will give to us. It will be granted. We've been in contact with them.
I have no further questions. Wait, excuse me. Have you ever designed a retaining wall with a TCE rather than fee simple title adjacent to it?
I'd have to go back and look at my plans. A certain wall doesn't pop into my memory right now.
Have you ever designed a retaining wall that's less than 5 feet from the right-of-way line?
Yes.
I have no further questions.
All right. Mr. Dix, do you have anything further?
Yes, if I may, sir. Ms. Spees, have you done anything differently than you normally do when you design a roadway project?
No.
And how long have you been doing this?
18 years.
Okay, as far as the permits, are we following the progression that we should follow to obtain the permits?
Yes, we are.
Okay, in your opinion, ma'am, we need this property in order to complete the project. Is that correct?
That's correct.
Okay. Mr. Marcy, whether or not it's a TCE or whether or not it's a fee simple, that's to be determined or argued at the order of taking hearing, sir.
All right.
That's a necessity matter. So,
All right. Any other witnesses, gentlemen? Either attorney have any other witnesses? Mr. Wilson?
No.
Mr. Dix, have any other witnesses?
No, sir.
I'll allow each of you just a few minutes in closing if you want to do that. Mr. Wilson?
Mr. Marcy, I want to thank you for your attention and for your obvious preparation for this hearing. The issues, I reiterate again, are the same, as I said at the beginning. Mr. Dix is absolutely right. The issues of necessity will be determined at an order of taking hearing, which has not yet occurred. And those issues of necessity will determine where the right-of-way line is. And where the right-of-way line is will determine the need for the variance. And we are going to argue, and I think with some good basis, that the department does not need that additional 5.8 feet in fee simple title. And if they simply have an easement across that property, it's still, we're the underlying fee owner, and we can use that to meet our setback requirements. So that is something that will occur at the order of taking. And that goes to my point that this is premature, that they have not demonstrated that they are seeking the absolute minimum relief from the setback requirements. And as I said at the beginning of this year, we want to have relief. We want, of course, clarification on whether that relief is legal nonconformity or whether it runs with the land. Based on all of the documents that the city has generated don't come out and say it, I think we're in the legal nonconforming category. But I think this is premature, and again, I think you've heard, there's no notice that was given to the owner that would meet the minimum due process requirements of the Fifth Amendment. And in Chapter 166, if you're making a zoning decision, you might have to post and give notification to adjacent owners, but certainly you have to give it to the property owner. And the city code, well, it says that either the owner or the DOT may file an application. The city code does not relieve the DOT of giving the owner notice. It just says either one can file the application. And if you look at the application, notwithstanding what you've heard today, the application itself says if you're not the owner, you have to get an affidavit from the owner. So we think it's improvident at this point to grant the variance, that at the very least the variance issue should be postponed until we know what property lines we're actually talking about. Mr. Dix is right. That'll be determined at the order of taking hearing. And that's after that hearing is when we should reconvene and decide what setbacks are required. Thank you.
All right. Thank you, Mr. Dix.
Sir, I'd like to thank you for your time this morning, too. As to the due process issue, I'm going to leave that with the city attorney. That's not a matter for the department to discuss, whether or not the city's codes meet the due process requirement. So I'm not going to address that. I am going to address the fact that this is not uncommon for the department to acquire property well before the project is constructed. That's how we do things. The other thing, Mr. Marcy, is we've made an offer here. So we're bound by that offer. If things change and the value changes regarding this taking, that's a completely different situation. So the other thing, sir, is I've had my engineer that has been working very prevalently on this roadway design for this particular project, bind the department to the plans as they are today, as they're situated today, in regards to this particular process. So I don't understand the issue here. As to the TCE versus the fee, again, sir, that's something that probably should be addressed at the order of taking hearing. Obviously, it sounds like Mr. Wilson's going to oppose the taking, and that's something that the court will address at the order of taking hearing. And in regards to that, sir, you've also heard testimony from Ms. Spies that this taking is necessary. The fee taking is necessary as the construction project is designed. So she also bound the department, sir, as I stated. As to the issues with the application, I'm going to have to defer to the city staff on that. I suggest that this is an ongoing situation that happens every day or every month with roadway projects. And I'm going to defer to the staff on that. And I know that it's the city's position as far as the city staff that they recommend this, approval for this. And I believe we've demonstrated to you, sir, this morning that we're not trying to hide the ball on this. There's nothing different than how we normally proceed. We're trying to do everything by the book, and we feel we have done everything by the book, sir. And I have nothing further at this point.
Well, I have a question for you, Mr. Dix. How common is it for the Florida Department of Transportation to seek a deviation prior to the order of take?
Sir, as I understand it, it happens all the time that way.
Okay. All right. Thank you. Anyone else have anything to present? All right. I'm going to deny the application without prejudice to either the Florida Department of Transportation or the applicant to reapply after the order of take. I do see several problems with this application. First, I'm not willing to rule that the Section 2.9 of the Florida's Land Development Code does not comply with the Fifth Amendment. That is simply an issue on which I am not going to rule. I do think, though, that the Department of Transportation at least should have given notice to the owner that it was applying for this application, and to the extent that the Florida Department of Transportation did not, it put the city in an awkward position. I do think for future guidance from the city that it would be best practice to, if the applicant is not the owner, even if the applicant is the DOT, that there should be an authorization submitted with the application. And the reason for that is pretty simple. The standard order that is typically entered in these deviation situations does recite that the owner is in agreement, and without at least an affidavit from the applicant, if the applicant is other than the owner, there's no way really of being assured that the owner is in agreement once the order is entered. Having been an eminent domain attorney on both sides myself, I do know that what is being taken often changes prior to the hearing on the order of take, and certainly at the order of take. So right now, I don't see any way that I, acting on behalf of the city, can determine the minimum amount of deviation that's going to be required, because at this point in time, I'm not sure I know exactly what ultimately is going to constitute the take. First, I find it's premature. I do find that notice should have been given to the owner. I think there should have been an affidavit attached to the application. And I'm going to ask Mr. Wilson to prepare a proposed order and submit it to me. It should be submitted. My email for both Mr. Dix and Mr. Wilson is hrmarcy@cfl.rr.com. So, Mr. Wilson, if you'll submit a proposed order and do that quickly, I'll enter it. Anything else we need to cover while we're in hearing, gentlemen?
Yes, sir. As I understand it, you stated that we can reapply after the order of taking hearing?
Yes, or the owner, or preferably both.
Sir, that's going to hamper the department in taking the property.
In what way, Mr. Dix? Step up to the microphone here.
I'm sorry, sir. What's going to occur here is Mr. Wilson's going to use that as evidence against the taking. I can guarantee you that. So the reason why the department needs to get the deviation application is to affirm that the appraisal, which is for the property that's taken and any damages that occur to the property, is a valid appraisal. Well, if I don't have agreement for the city, I can do this. That changes the appraisal, sir. That can change the appraisal. Mr. Wilson can argue that in court.
Well, the issue of valuation, of course, is a separate issue. The appraisal can certainly be provided in the alternative, or you can both apply prior to the order of take.
Thank you, sir. That's all I request.
But what I'm saying is, if you're going to apply before the order of taking,
yes, sir.
I'm assuming this will come back before me, I'm going to expect that there at least be agreement on what the amount of the take is. Right now, I do not have enough information to make a decision until I know what is being taken, either having in my hands an order of the court saying this is what's being taken, or unless you and the property owner tell me, yes, this is what's being taken, I have no way of knowing the minimum amount necessary in the way of a deviation. It's just that simple.
Very good, sir. For the record, I just want to say one more time that the department bound itself to those construction plans that are in front of you, sir, that have been entered into evidence.
Well, I disagree with you that. What your engineer said, Ms. Spies said there should be no additional changes. And unless I see something to give me a reason to believe she has authority, should is aspirational. It is not a commitment. So I disagree with you on that, Mr. Diggs.
Very good, sir. I'm fine. I just wanted to reserve the right to reapply prior to the order of taking hearing if necessary.
Certainly. Typically, what happens is the owner and the DOT agree when they apply for these things. But certainly, the owner, the fact that no notice was given to the owner in and of itself is enough to make me deny this application.
Understood, sir.
Okay? Anything further? No. All right, then we are adjourned.